during that time, Mr. Cutts will have the opportunity to visit with his family. On the other hand, death is permanent. And these people that you've just heard from and others will never have the opportunity to visit with Jessie, to hold baby Chloe, to see her grow. And this is a particularly brutal crime. Because of this tragic and senseless act, the Davis and Porter families have lost two family members. They lost Jessie, who was a mother, a daughter, a sister. They lost Chloe, who would have been a granddaughter, a niece, and a sister. And what makes it even more brutal, Your Honor, is that at the time this offense was committed, this man was a police officer, a person that we teach our children to look up to trust, to go to when they're in trouble. On June 14, 2007, he violated that trust, Your Honor, in a brutal and senseless fashion because he purposely took two lives. And today in this courtroom, each of those lives deserves a sentence to be imposed so that justice can be served in this case. And I'm urging this court to impose every sentence that it can, consecutively in this case, so that this police officer, Mr. Cutts, spend as much time as possible behind bars. Thank you.
Thank you, Mr. Barr. Anything else come before the court where the court imposes a sentence? Counsel for the defendant. Very well. As has been alluded to, I am the trial judge who did preside over these proceedings, both the trial phase and the sentencing phase. I have considered all the testimony which I've heard, also considered the matters which have been brought to my attention this afternoon. I've also reviewed the principles and purposes of sentencing under Ohio Revised Code, specifically chapters 29-29. And I've also balanced the seriousness and recidivism factors. Every judge in the state of Ohio is sworn to uphold the Constitution of the United States, the Constitution of the state of Ohio, and to enact the statutes of the state of Ohio. There are three principles every judge follows in fashion in sentence. One is a sentence that will serve as a deterrent to this individual and to others, one that will not demean the seriousness of the crimes which the person has committed, and also which one will protect the other citizens of the state of Ohio. Again, the court finds that the defendant has been found guilty of murder in regard to count 1, aggravated murder with 3 death penalty specifications. The jury has dealt with those in regard to count 2, aggravated murder with 3 death penalty specifications. The jury has dealt with those in regard to count 3, 1 count of aggravated burglary, which is a felony of the 5th degree. In regard to count 4, 2 counts of gross abuse of a corpse, that's 5 and 6, and then child endangering, misdemeanor of the 1st degree in regard to count 7. Obviously, in regard to the murder charges, prison is mandatory. There was not any pre-sentence investigation which was requested or ordered in regard to this matter.
You've got mail.
Obviously, the court finds that community control is not available in this matter. Before I go any further, I am going to merge for sentencing purposes counts 2 and 3. In regard to count 1, the murder, as I've alluded to before, the sentence in regard to that is life imprisonment with the first possibility of parole after serving 15 full years of imprisonment. The jury has rendered its verdict in regard to counts 2 and 3, which the court has merged. That's life imprisonment with the first possibility of parole, eligibility for parole after 30 full years of imprisonment. So those two are merged for sentencing purposes. Aggravated burglary, as I've indicated before, a felony of the first degree can be punished by a prison term of 3 to 10 years in whole years. Each one of the felonies of the fifth degree, the gross abuse of a corpse, can be punished by a prison term of 6 to 12 months in whole months. And the endangering children, misdemeanor in the first degree, 180 days local incarceration, which by law must be run concurrently. The court finds that it is appropriate to run all of the sentences consecutively. In regard to the felony of the first degree, aggravated burglary, the court imposes a 10-year prison term. In regard to each one of the felonies of the fifth degree, gross abuse of a corpse, the court imposes the maximum again, which is a 1-year prison term. That means that there's a 15-year first-time eligibility for parole in regard to the murder. It means that it's 30 years in regard to counts 2 and 3. Those are to be run consecutively. In regard to the felony of the first degree, 10 years, that's to be run consecutively. In regard to each felonies of the fifth degree, 1 year, and those are to be run consecutively. You add the 15, the 30, the 10, and the 20, and the 2 years for each one of the felonies of the fifth degree. My math is right. It comes out to be 57 years. That's the sentence of this court. Everything is to be run consecutively that by law can be run consecutively. Mr. Cutts is to be given credit for jail time served against the 10 years and the each one of the 1 years, so that's against the 12 years, but by law, the 15 and 30 years which are run consecutively, that's full years of imprisonment. That does not include jail time credit which he has served in the Stark County Jail. He is required to pay the cost of these proceedings. Additionally, the time that he is released from prison, the defendant is advised that the Adult Parole Authority will place you on a period of mandatory 5 years post-release control. If it's alleged and found that you violated the terms and conditions of your post-release control can be made more restrictive, or in the appropriate case, your post-release control can be revoked. You can be returned to prison even though you've served your full prison term. Now, before I go any further, because there are fines that can be imposed, and I'm going to need to address appellate rights in just a minute, and so I will be asking about the indigency or non-indigency status of the defendant. But before I go any further,
Okay, bottom line is, to run consecutively means they can't be bunched together and run all at the same time. He has to serve one, then the other. So bottom line, 57 years before he's up for parole. And Bobby Cutts Jr. will be 87 years old. Basically, the rest of his natural life in prison. Way to go, Charlie Brown.